Thanks for joining us. Beginning the bulletin, and a lawyer for Daniel Owusu Koranteng, the suspect who was arrested in the Ahmed Suale murder case, has maintained her client's innocence, alleging that his former employer, Tiger IPI team, are behind his arrest. According to the lawyer, Daniel Koranteng was accused by his former employers of selling videos and pictures of Ahmed Suale to Kennedy, Japan, which ultimately led to the death of Ahmed Suale, a claim she describes as baseless.
He went to Dubai with Anas, and on the return, there was some ill feelings. Daniel Owusu Koranteng felt hurt by some things that Anas did to him, and then decided at that point that he was done.
So there was a little bit of bad blood between Daniel Koranteng and Anas Anas.
Daniel Owusu Koranteng did not have any bad blood with anybody. All he said was, I do not like the way you treat me, and so I'm walking away to think about how to progress my life.
Was it about money?
Well, at some point, yes, because he claims, or the audios that we have as evidence goes to prove that when they went to Dubai, Anas had a problem with him because I think he was supposed to do something and it didn't happen. And Anas ignored him in Dubai for 3 days, in which he had to now look for sources or ways and means to survive in Dubai.
Whilst on operation.
And he felt that that was unacceptable on all levels because he loved him, he loved his family, he loved the man. So for you
Daniel
to do that,
Koranteng loved Anas.
yes, he did.
Okay.
He really liked. He really loved him.
Okay.
He was one of the people who showed him his trade.
Anas showed Daniel Koranteng his trade.
Yes.
And that's what he does now with what he's doing.
Exactly.
So he trained him.
More or less.
Did he also meet Ahmed Suale whilst he was working with Anas?
Yes, he did.
He knows him well?
He knows him well.
So when he was leaving Tiger Eye, did he tell Anas that he's leaving?
Well, he did not exactly tell Anas that he was leaving, but he said it in the grapevine that he was done and he was going. When he said that, one guy called Muda called him into an uncompleted building and shot in the air. The Muda didn't say anything according to the narrative. He did not say anything to him. He just shot in the air. So Daniel Owusu Koranteng just kind of thought that this was a threat. So he just decided to just back away.
Time of Ahmed Suale's death, he was not an employee of Tiger IPI.
So by the time Ahmed Suale died, he was not a member of Tiger IPI.
No, he was
the lady what be named?
Are you sure about that?
Yes, he says it here. He was not. He said, I have resigned. I don't want to have anything to do with them. But you too be mindful, because anyone who is leaking videos that could not have been leaked after you left is trying to implicate you. And today, we are all here because Daniel Owusu Koranteng is accused of leaking pictures.
To your knowledge, or to Daniel Owusu Koranteng's knowledge, did Ahmed Suale fall out with Anas Anas?
Well, it would appear so, because from the narratives or from the text messages, he had a lot of complaints about him. He had even said in one of the text messages that if he were to talk, what Ken did was small.
Oh, that's interesting.
Yes, he even went ahead and said that you do all these efforts and you are not appreciated. So he had some...
And you have these text messages?
Oh, yes.
What then was Ahmed Suale doing by the time he died, to your knowledge?
I have no idea what he was doing. Because I think he said he was going to lay low in one of the text messages. And after that, my clients never had any interactions with him again.
And that was a lawyer for Daniel Owusu Koranteng speaking to Paul Addo there. Now, way to a story that is making the way in the media space. That is a joint operation by national security has led to the arrest of 8 Chinese nationals and 1 Ghanaian in connection with the disappearance of Electricity Company of Ghana containers at the Tamale port. There's more in the following report.
The arrest came after investigators traced cables suspected to be part of the missing shipment to an aluminium smelting facility owned by the Chinese nationals at Shai Hills Acting on intelligence, security operators raided the facility, apprehending the suspects as part of ongoing efforts to unravel the case. This development is the latest in the investigation into the ECG container scandal, where over 1,300 containers filled with electrical cables and other essential equipment have gone missing. The Minister of Energy, John Jinapor, earlier announced that the government will launch a criminal investigation into the incident. He emphasized the need for a forensic probe to uncover how the containers were removed from the port and where they ended up. He confirmed that an Indian national has been arrested in connection with the case, noting that the suspect claims to have legally acquired the containers last year.
We'll definitely keep our eye on that particular story and bring you more subsequently. Now, away from that, some smallholder farmers in Gotime, Alabono, located in the North Tongu district of the Volta region, are calling on the government to intervene in a land dispute that threatens their lives and livelihoods. According to the farmers, the land they have cultivated for generations has been taken over by investors who claim the government acquired the land without their consent. They allege that these investors are using the police and security forces to intimidate them, preventing them from accessing their farmlands.
Metro TV's Volta regional correspondent Gabriel Asempa, who visited the affected farms, reports that the land in question was acquired by the government in 2012 with assistance from the World Bank. It was aimed at providing irrigation for smallholder farmers to boost and add value to their crop cultivation. The completion of the irrigation project included the construction of canals. However, an unfulfilled part of the agreement led to investors preparing the land for crop cultivation without the knowledge of the landowners. The investors have now deployed security personnel to intimidate the landowners and prevent them from accessing their farmlands. The farmholder farmers claim the authorities of the Pond Irrigation project have failed to uphold the agreement made with them when the land was acquired. Speaking to Metro TV, the farmers, dressed in red and chanting war songs, expressed their frustration, vowing not to sit back and allow the investors to take their lands. Maulawe Jomato is the chairman of the Smallholder Farmers Association.
After they finish, the local farmers will have theirs. Then the big farmers, the investors, will also have theirs. Then after they finish, what we got to see is they share the land among themselves. We have land allocation committee on the project. The land allocation committee, they don't even know they share the land. So the only thing we see, the big farmers start to dress our farms. You go to your farm, they destroy the farm, and they say they buy there.
Agbovi Peter and Lydia Titunoviogbo are two of the affected farmers who also voiced their grievances.
They destroy our farms, including our cassava farm, and it is bringing tension among us. It is the government that brought all this suffering to the community. We want the government to return our farmland to us so that peace can prevail.
The investors are now telling us that we cannot cultivate our land anymore, and they brought in security personnel to the farm to intimidate us. We are calling on the authorities, especially the MP and President Mahama, to help us.
The assembly member for Alabono electoral area, Promise Sakbasu, described the situation as alarming and a serious threat to the community's well-being. He urged the government to intervene before the situation escalates.
Government brought in some representatives from World Bank to introduce to us that they are coming to add value. They realize there is poverty here, so they are coming to eliminate it by constructing canal here to introduce irrigation farming for us to be working here. So there was a time they came and told us to vacate from the land because they're coming to develop the land. And before we realized, they've started giving out the developed land and then undeveloped land to big-time investors. So, and now they have occupied the majority of the land working on. And meanwhile, the indigenous hasn't gotten their land yet, as we speak now. So the indigenous are always struggling to have farmland to work.
Now, the Ghana Irrigation Authority responsible for the North Tongu and Esuchari water project is calling on the government to support them with farm equipment to enhance rice production. According to the management of the North Irrigation project, the lack of essential equipment for harvesting and plowing is a major challenge. Our reporter Gabriel Sempa visited the farms and has come through with this report.
The North Irrigation project is one of the largest irrigation initiatives in Ghana, serving 3 regions, Volta, Eastern and Greater Accra. However, the project has struggled for a long time due to financial constraints. Although the World Bank recently provided a loan for rehabilitation, the project still requires permanent farm equipment to operate efficiently. Project manager Moses Kodoche lamented that the lack of rice processing machines, combined harvesters and other essential tools is severely affecting their projects.
The scheme is a mechanized scheme, so it can be is mainly mechanization, and no mechanization go with machines. So if the machines are not enough for farmers, the production also will be doing that. So for now, the major challenge is to get the land preparation machinery to be enough for farmers. You know, it's driven by a private sector. So those private service providers, they are helping us to move. But you know, if machines are enough, it will curtail some of the challenges we have.
The project manager also said they need immediate government intervention to provide the necessary equipment and infrastructure to sustain the project.
A combined harvester harvest a hectare of rice for you this time. They are taking 2,300 Ghana cedis just to harvest a hectare of it. When they said cost of spare parts, cost of fuel, cost of lubricants. So they also want to, the private man want to make it's a businessman, they want to make a difference. So even if you don't agree, then your rice will be left on the field and got spoiled. So you have to fight the enemies and then go in for it and make sure that your rice is not spoiled on the field.
Additionally, individual rice farmers and processors in the area are urging the government to produce flexible loan schemes and provide subsidized fertilizers similar to the support given to cocoa farmers. They also highlighted that if the government can assist with storage facilities, it will help prevent post-harvest losses and allow them to store their rice effectively. Once rehabilitation is complete, the project will be back in full operation, but more government and donor support is needed to ensure its sustainability.
So watching the news updates here on Good Afternoon Ghana, we go back to the Volta region, and students and staff of Presby DA Basic School in Mepe in the North Tongu district of the region now have a reason to smile as they received a newly rehabilitated and furnished 7-unit classroom block. The classroom block, which was previously used as shelter for residents who were displaced by the Akosombo Dam spillage disaster, has now been transformed into a conducive learning environment through the efforts of Right to Play, an NGO in education with support from the Church of Jesus Christ of Latter-day Saints. During a short ceremony to commission the project, the country director for Right to Play, Josephine Mukaka-Lisa, stated that some schools in North Tongu and other districts need attention to improve the teaching and learning environment for students.
Many more schools with North Tongu and other districts require more support. But as you also are aware, the international aid is becoming reduced, calling to our communities to use the resources we have to put together our hands, our effort to contribute to the development of our communities. That's why in our intervention in schools, we come and sit together with you and develop a school plan where we identify the contribution of every one of you. So let's continue to work together to see how we can do more on infrastructure, but also on the learning of our children.
For still on education, the Director of Education for the Lower Manyakrobo Municipal Assembly, Samuel Kwesi Tete, has called on parents, teachers and stakeholders to collaborate in tackling the rising issue of teenage pregnancy in the area. He said teenage pregnancy has become a pressing concern in the municipality, necessitating a unified approach in addressing it. He was speaking at a press conference within the constituency.
The Educational Directorate of the Lower Manyakrobo Municipality organized a program under the theme Beyond the Dreams of Teenagers in Agomenya, Eastern Region. The event formed part of measures to eliminate teenage pregnancy among adolescents in the municipality. Manyakrobo Municipal Director of Education, Samuel Kwesi Tete, in his address said teenage pregnancy has far-reaching consequences affecting not only the education and future prospects of girls, but also impacts negatively on the economy and society. Tete urged stakeholders to provide support and guidance to young people, especially girls, to make informed decisions about their reproductive health and education.
The reason why most of our guests are unable to rise to the top is teenage pregnancy. In fact, it's very rampant here. And it is also affecting their education. Most of them drop out of school. Some become young mothers, and as a result, they cannot continue. Even though we have this back-to-school campaign, there are certain things that will not allow them to come back. One, they feel that becoming pregnant and coming to school, their children, their friends themselves are going to laugh at them. And then again, even when they give birth, they put to bed and they want to come back, there's nobody to leave their children with to take care of them for them. And so it's becoming something that it is not allowing them to progress on the academic ladder to the highest point that their abilities will allow them. And so our objective is to make sure we educate them, not them alone, their parents and all who have a role to play as far as teenage pregnancy is concerned. So together we'll put all hands on deck and make sure we help our girl child to grow to whatever level.
Meanwhile, Nanada Brabekwe Isaac, a philanthropist and leader of the Asai Grow Foundation, has appealed to community leaders and stakeholders to support initiatives aimed at reducing teenage pregnancies.
We interacted with the Municipal Director of Education, Mr. Samuel Tete, and he came out with some of these things, that even some of these children at the primary level had to drop out of school due to teenage pregnancy. So Asai Grow was here to help the Education Directorate to fight against it, so that at the end of the day, our children can continue the education war, continue their career, and also come out successfully with whatever ideas, dreams that they want to accomplish.
Now away from that, British filmmaker and actor Idris Elba has been in Accra over the last week and among other things met with President John Mahama to discuss his projects to bring the film industry back to Africa and tell African stories. He proposes collaborating with the government and utilizing part of the coastal land near the Owusu Castle to develop an ultra-modern film and creative village to train and employ creatives and the school to serve. Let's listen to Idris Elba and the President.
We're here to make a presentation to you, but also we're just hoping that this is a conversation. We want to build this with you. I know that you have been very focused and briefed on the creative opportunity and creative sector. And, you know, by way of working with you on Beast of No Nation those many moons ago, you know, we are still very dedicated and focused on bolstering creative sector of Ghana. I'm working for 30 years and I'm at a junction now that I can perhaps bring work to where I am, where I want. So in this instance, to be able to bring international work and films that I'm in into our own facility in Ghana, it is important that we are competitively forward-facing when it comes to our policy. So everything from how, you know, cameras and things, custom relations, to taxation on certain products, to local labor laws, all of those things are very important to be able to demonstrate when I say to Apple, I want to shoot in Ghana. They have no reason to say no because most shoots are inside a studio. You don't even know where you are.
With the old castle, we can't change it too much because it's a UNESCO heritage site. And so we can just, restore it, to what it should be. It's been abandoned for quite a while. There was a credentials hall and all that, and then there's the room where Prof and Rawlings used to stay and all that. It will be interesting for, tourists to be able to see those places, the Queen's bedroom and all that. Do some urban planning around here. Yeah, because the traffic is going to bring into that district. You need an urban engineer to make sure that you don't have a gridlock in the area. You need to look at parking, because it looks like it's all built up in green space. There must be enough parking space, either a multi-story car park or something, and then maybe a one-way system that brings people right down by the Independence Square and then come in somehow, and then going out, they take the other way out.
Now, the final funeral rites of the founder of the Kama Group of Companies, Michael Agyekum Addo, is underway in his hometown, Sushen, near Koforidua in the eastern region. The revered businessman passed away on Thursday, October 31, 2024, at the Kolebu Teaching Hospital here in Accra. The new job in Traditional Council, the Sushen Hema, and the business community have expressed their grief over the loss of the business colossus and astute statesman, highlighting the significant role he played in driving economic development in the country.
Eduha, Obabe Yansi ye, that's mo, that's ya, Aquaba, Sanatia, Tokrania Trasse, Waba na Unyanko Haya Papa, and one Sabako and Tintin Swaho, see a Trasse nay, a old son of Pa, and Sunny Bepedemu, in two Bena Pedamuka Canwa Saba Trasse Maye, Yasum Sa. For Yadamase.
When you are saying, I know we enter. As someone who when you swing your mouth, wow, when it's someone who are yet you never go
yewe. Osama Pania to the bedi. Osama Pania. Osama Pania to the bedi. Nana Jemi we. Jemi bedi. Nana Biambo Ukomo. Nana Jemi we. Kejana Metro. Jemi bedi.
Those are live pictures from Susha in the eastern region, where the final funeral rites of the late founder of the Kama Group is taking place. And of course, you can tune in to 91.9 FM, Original FM, and our sister station, Original TV, for more on that. And that's wrapping up the bulletin this afternoon on the show. I am Desmond Okreko. Dancer back to Annie for the rest of the bulletin. Annie.
Essie. Thank you so much for the updates. I'm just hearing, I'm picking up information that some persons also, I'm not sure the details of the people are involved, but I'm hearing that persons are seeking for either the removal or the resignation or the impeachment of the president.
Which president?
This one is going to be a long year.
No, I'm just like, which president?
How many the president of the Republic of Ghana.
Is that why
Well,
what has it?
Not everybody is necessarily happy with what's happening. So let's see. I mean,
we'll see how
it's
that
an
goes.
interest that has been expressed. We'll be following through to see if that actually holds water or it's just people.
I know some people have also talked about the EC chair. I know that we'll see.
Yes.
Yeah.
It's going to be a very long year. Yeah. A lot of prima facie case to be made.
Yes.
Thank you for the update of the news. And you're still watching Good Afternoon Ghana. That's just gone by. It's an update of news bulletin, given to us by Desmond Okreko. Right. Let's take a breather. And when we come back, we definitely will go into the details of these news stories have been given to us, especially delving more into the legal matters that are arising as far as the removal of the CJ or the Chief Justice is concerned. A lot of developments. We'll get into that. We'll be back after this break.
Attention all farmers, are you ready to take your crops to the next level? Introducing 3 effective organic composts that will revolutionize your farming practices. ACAP, KCAP and Irrigation brings to you the ultimate solution for your fertilizer needs. Introducing the ACAP Grade A, KCAP Equiafua Jinkwa and the Irrigation with cocoa blends, palm blend and mulch. These are made from locally sourced municipal solid waste, and these are the perfect choice for sustainable farming. Join the organic revolution today. Boost your crop yield, improve soil health, and support sustainable farming practices. Choose ACAP, KCAP, and Irrigation organic compost for a greener and bountiful harvest. For your purchase and more information, call the numbers on your screen. Our products are endorsed by Cocoa Board, Planting for Food and Jobs, and the Ministry of Food and Agriculture.
Step up with DSTV and we'll show up by giving you more incredible entertainment.
Going to have a little fun.
Upgrade your subscription between the 13th of January and the 31st of March and get an even higher package for a whole month on us.
Buckle up, here we go.
There's nothing better than putting a little bit in but getting a lot out.
Time to boost some office morale.
Incredible!
When you want to build a future, you gotta know what you want.
Step up and we'll show up on your home of entertainment, DSTV.
Welcome back to Good Afternoon Ghana. Now let's get into the legal issues that have arisen in the country. First of all, we'll touch on the Chief Justice's, petition of her removal. Apologies of her removal. It has actually gotten to the president. The president has tasked the Council of State to look into it and see, how to proceed from there. We'll get into the letter, but let me just read this for you updates that. The Supreme Court has set April 2, 2025 to hear an injunction application filed by the New Patriotic Party NPP Member of Parliament for the Old Tafo constituency, Vincent Assefa, against the procedure being used by the President to potentially remove the Chief Justice from the office following the receipt of 3 petitions.
Comes shortly after the Chief Justice Agyekum Tokonu wrote a letter to the President and copied other stakeholders demanding copies of the 3 petitions seeking her removal from office. The CJ's request came shortly after the suit by the Old Tafo MP at the Supreme Court, questioning the procedure being used to handle the petitions. In the view of the plaintiff, who is being represented by Godfred Dame, the former Attorney General, a Chief Justice ought to be alerted of the petitions to give a response before the President can consult the Council of State on the petitions. The Minister for Government Communications, Felix Kwachiofusu, confirmed that the 3 petitions have been forwarded to the Council of State in line with Article 146 of the 1992 Constitution. The Council of State is expected to review the petitions and provide guidance to the President on the appropriate course of action. In her letter to the President on Thursday, March 27, Chief Justice Tokonu requested a fair opportunity to respond to the allegations against her before further steps are taken.
So this is a summary of, what happened. Before we'll give you the details of what the Chief Justice said, but this is the details of the letter. We have been tackling this letter since it was released by the President, signed by Felix Kwame Owusu. He says, President Mahama consults with the Council of State on 3 petitions for the removal of the Chief Justice. So the petition actually says that President Mahama has received 3 petitions from the various persons seeking the removal of the Chief Justice, and the President has forwarded the 3 petitions to the Council of State to commence the consultation process mandated by the Article 146 of the 1992 Constitution, signed by Felix Kwame Owusu, spokesperson of the President, Minister of Communications, Government Communications. And this is what's, a very brief letter, but that's what has attracted so much controversy and criticisms that the procedure or the process that this is going through is wrong. There are some lawyers who have indicated that even making the petitions public was not the right thing the President should have done. Anyway, we'll get all into that because we have a lawyer with us to let us understand. But now the Chief Justice, Gertrude Sakitokon, also has requested copies of the petitions submitted to the President, John Dramani Mahama, seeking the removal from office. In a letter to the President on Thursday, March 27, she appealed for access to the documents to enable her respond accordingly. Her request comes after President Mahama initiated consultations with the Council of State following the submission of 3 petitions calling her for the removal. And here are some excerpts of the letter. So on your video wall, let's see if we can capture them for you. It says that, up to date of 27th March 2025, I have not been shown the 3 petitions mentioned in the communication of 21st of March 2025 or given an opportunity to respond to them, which material is expected to form the premise for the consultations between the Council of State and Excellency, the President. Wider Article 146, Clause 6, as to whether there is a need to set up the committee of inquiry described in Article 146, Clause 6, and Article 146, Clause 7, for the trial of any issues raised. Continues to say, I have handled 5 such petitions for removal of Superior Court judges and heard from them before determining whether a prima facie case has been made against them to merit the setting up of investigative committee provided for under Article 146, Clause 4. And we'll get into the articles, you know what it says. It continues, it says that it is in combination of evidence in the petition and the response of the judge that guides the Chief Justice to determine as a sole inquirer under Article 146, Clause 3, whether a prima facie case has been established against the judge to merit the setting up of the investigative committee of 3 justices and 2 eminent citizens to conduct a hearing of a complaint against the judge pursuant to Article 146, Clause 4. I am, by this letter, humbly and respectfully asking His Excellency the President and eminent members of the Council of State to forward the petitions against me to me and allow me at least 7 days after receipt of same to provide my response to you, which response can then form part of the material that you conduct and you conduct the consultations anticipated under 146 Clause 6 before the possible setting up of committee of inquiry under Article 146 Clause 7. So meanwhile, a citizen or Ebenezer Osei Owusu has also petitioned the Supreme Court to stop the President John Dramani Mahama and Council of State from proceeding with the processes regarding the removal of Chief Justice Gertrude Sakitokon. Now here are the reliefs sought And so let's turn to the video wall again and then give you the details of that. And it says that the President of the Republic of Ghana, acting in consultation with the Council of State, cannot appoint a committee to inquire into or make recommendations on the petition for the removal of the Chief Justice without the first furnishing the Chief Justice with a copy or copies of the petition seeking her removal and to comment on them. And an order of the court setting aside the decision of the President of the Republic of Ghana to consult with the Council of State and forwarding 3 petitions seeking the removal of the Chief Justice Gertrude Isaba Saki Tokonu as being unconstitutional, null and void, saying having made without first furnishing the Chief Justice with a copy or copies of the petition seeking her removal and affording her the opportunity to comment on same. Do we have more of these reliefs? Okay. An order of injunction restraining the President of the Republic of Ghana from the proceeding to consult with the Council of State to determine the existence or otherwise a prima facie case against the Chief Justice of the Republic of Ghana, Gertrude Isaba Saki Tokonu, and also from constituting a committee to inquire or make a recommendation on the purported petitions for the removal. So we have another, reliefs that has been made this time by a member of parliament. I don't know if we have it ready so that we can put it all together. This is what's it called? A relief by another individual, or say a Ghanaian, who is interested in this matter and has also gone to court. Now, Vincent Assefa, also a lawyer and a member of the NPP, has also gone to court as a citizen of the court. Is this okay? So I think we should have that also on graphics, so you can just get the reliefs in briefs. All right. As and when we get it, we will speak to it. But for now, let's come back into the studio and then get the understanding on all the issues. We will have Vincent Assefa join us pretty shortly. They are all in Parliament. No, Parliament is also rising, and they are heavy on assignments and work on the members of Parliament. So as and when he makes some free time, he will spare us and then get some more explanation from him. But for now, I have in the studio with me, of course, lawyer Eric Dela Alifa, who is also a member of NDC. Let's get it straight so that nothing is, missing. However, he will help us understand what the legal procedures, because right now the questions are on legal procedures for all those seeking reliefs of null and void, or to declare, for the court to declare this null and void, is due to procedures which they think are misplaced. And so we'll get into it, and then we will understand exactly what's happening. Lawyer Dela Alifa, you're welcome. Good afternoon to you. Thank you. Thank you very much. Good afternoon. It's been a while. It's been a while. Now, I mean, every time I need some legal... Oh, your microphone is on, please. His microphone is on. All right. So anytime we have some legal, issues, we get to him. He's almost becoming a friend of the Good Afternoon Ghana team. Thank you once again. Okay, I haven't seen you this year, so maybe with all that's happening, give us an opening of what you think. We seem to have started this government on a legal battle, back to back.
I was thinking that I would hear of the citizens of Ghana from submitting a petition to the president. I haven't heard about that one.
Oh.
Trying to stop everybody from submitting a petition, because you see, the point is that once the petition is delivered to the president, the Constitution prescribes a process, a procedure, what the president must do. So, well, if the petition comes and you are telling the president that don't go ahead with the process, then it might as well advise all Ghanaians also not to submit the petition to the president.
Yes.
So I haven't heard about that one yet.
No, and I don't think that petition has been submitted, asking for the president to step down.
No, not for the president to step down. I am saying that when citizens, petitions written by citizens of Ghana, right? So the Constitution says that once a petition is brought to the president, there's something he has to do.
Yeah.
There's an action he has to take. So if the president will receive petitions and people will now go to court and be trying all kinds of tricks to prevent him from doing what the constitution says he must do.
Okay.
And they might as well advise Ghanaians or citizens also not to submit any petition.
Yes.
Yeah, that's what I'm saying. That's the point. But anyway, that's just by the way. But the process is very clear in the constitution, and I don't think that anybody who is arguing this matter. It's a very simple process. The constitution is very clear. Simple words. Because about in fact, when you read the article, the removal of justices of the Supreme Court, justices of the Superior Court, and the Chief Justice. When you, the one we are dealing with now is the Chief Justice. Any justice other than the Chief Justice, Superior Court other than Chief Justice. That was Article 146, 3, 4, 5 deal with that. You see that that is the only place the prima facie was mentioned.
Okay. I just hold on there. I want to engage Vincent because maybe, yes, officially, he is the first person who actually started this battle after the petitions were presented to the Council of State. Vincent, Honorable Member, you're welcome. Good afternoon to you.
Yes, good afternoon.
All right, thank you for your time. Before I get to you, just a brief or briefs about Vincent's reliefs that he sought for the courts to do. I'll give you just a bit of it. He had about 4 reliefs that he was seeking or pleading the courts. He says that that's a declaration that upon a true and proper interpretation of Article 146, Clause 1, Clause 2, Clause 4, Clause 6 and 7, 23, 57, Clause 3, and 296 of the Constitution, the President is mandated to notify the Chief Justice about the position for the removal of the Chief Justice and obtain his or her comments and responses to the content of such petitions before referring the petition to the Council of State or commencing the consultation process with the Council of State for the removal of the Chief Justice. Relief 2, it says that the declaration that upon a true and proper interpretation of Article 146, Clause 1, Clause 2, Clause 3, Clause 6, and 723, and 296 of the Constitution, a failure by the President to notify the Chief Justice and obtain his or her comments and responses to the petition for the removal of the Chief Justice before triggering the consultation process with the Council of State constitutes a violation of the Article 146, Clause 6, as well as the constitutional protection of the security of tenure of the Chief Justice, blah, blah, blah. The third one, it says that the declaration upon a true and proper interpretation of the articles. So as I've mentioned, Article 146, we'll make reference to it as we go on. 146, and it says that the President to notify the Chief Justice and obtain his or her comments and responses to a petition for the removal of the Chief Justice before triggering the consultation process with the Council of State amounts to an unjustified interference with the independence of the judiciary enshrined in Article 127 and Clause 2 of the Constitution. The fourth one says that a declaration that the failure of the President to notify the Chief Justice to obtain her comments and responses to a petition for the removal of the Chief Justice before the triggering of the process of her removal constitutes a violation of the fundamental rights to a fair hearing contained in Article 23 and 296 and renders the consultation process for the removal of the Chief Justice initiated by the President null and void and no effect. All right. So Vincent, thanks for your time. First of all, let me take you to a response from Tadia Sori, who has seen your maybe suits, I'll say, And he says that how did Mr. Assefa within just one day ascertain the Chief Justice was not consulted before the petition were referred to the Council of State? 2, did the Chief Justice personally inform him that she was not consulted? And take note, the word is consulted here. Was there any media report confirming that the Chief Justice had been bypassed in the process? And the Chief Justice believes in the law. There is no need for the presumption protection. Every Ghanaian believes in the law. And he says that you should allow the law to work. Hello, Vincent.
Annie,
yes.
Is it possible?
Yes, I can hear you.
Of the information, I got to know of the information from the corridors of power. You as a journalist, when you have cause to investigate matters, do you come and tell the Ghanaian people your source? The most important thing is the credibility of the information that you're putting out there. And so if Tadio Sori is suggesting that maybe I have spoken or I have conferred with the Chief Justice, I am also suggesting to him that it is also possible that I got the information from the corridors of power.
Okay, you got the information from the corridors of power that the Chief Justice was not consulted.
I am also suggesting, I am only saying that it does not lie in the mouth of Tadio Sori to, as it were, suggest that I am, as it were, in engagement with the Chief Justice. I am also suggesting that that cannot be the only conclusive statement to make or a conclusive question to ask, because it is also possible that I got my information from the corridors of power. I am only saying that it is the credibility of the information that I put out that is more important, but as to how I came by that information, it's none of his business with the greatest of respect.
Okay, I get your point. So how you came by the information you say is none of his business, but the substance of your statement also touches on consultation, not so? If we can
Absolutely
go into
so.
yes, we can go into the article and then and see what it actually means, that 146 and all that, and 296.
You see, you
that
cannot read 1466 alone. You have to read 1466 and 1463. It is the combined effect that will give you the true meaning of what Article 1466. Because I took my time to read my senior colleague's argument, that is Tadio Sori. It was bereft of SUA JSC's admonition. The interpretation of a constitution should be. SUA JSC said that in interpreting a constitution, you need to do so with the letter and the spirit of the constitution, so that you can have a true meaning and reflect the intent of the framers of the constitution. You cannot simply say that the letter of the constitution says so, and for that matter, even if in interpreting the letter of the spirit will bring about absurdity, you should still go ahead to interpret the constitution that way. No, the Interpretation Act clearly says that currently, in interpreting our constitution, you do so by way of a modern purposive approach, which has been stated clearly in the Interpretation Act of Ghana. And so the point I'm making is that the combined effect of Article 1463 and 1466 gives the true meaning of what Article 146 is. Because Article 1463 talks about how a justice of the Supreme Court will have to be removed. But Article 146 says that in removing a Chief Justice, a certain process will have to follow. But you see, that Article 146 only talks about appointment of a committee. But if Article 1463 is saying that you need, or the Chief Justice will have to establish a prima facie, mind you, the Chief Justice is first and foremost a Supreme Court judge. And if upon a petition to the President of the Republic of Ghana, her subordinates are supposed to be removed, and she is the one to establish the prima facie. If the issue it is about her, if the issue is about the Chief Justice herself, who establishes the prima facie case? The one who established the prima facie case, in my understanding, is the president himself. Before he can trigger the consultative process in Article 1466, because you read it in pari materia with 1463.
So
the point I'm making.
So I hold on. So let's do the reading, okay? So 1463. If the president, and we're talking about removal of Chief Justice of Superior Courts and Chairman of regional tribunals, just for the purposes of the viewer, if the president receives a petition for the removal, this is clause 3, for the removal of the Chief Justice, a Superior Court other than the Chief Justice, or for the removal of the Chairman of the regional tribunal, he shall refer the petition to the Chief Justice, who shall determine whether there is a prima facie case. 6, clause 6, where the Chief Justice decides that, 6 says, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices for the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of the Parliament, nor lawyers. Help me understand how you did a combination of these 2 clauses and still came to the conclusion that the President was not following procedure.
So my point is that you have to read the combined effect of 2, 3 and the 6, okay?
Yes.
The 3 says that the Chief Justice will have to establish a prima facie case.
Yes.
If it is a matter is the judges, right?
Mm-hmm.
Right?
Right.
Absolutely. So if it is a matter that is also in relation to the Chief Justice herself, my question to you is that who establishes the prima facie? The prima facie is a decision on its own.
No,
it's a decision on its own. The decision, hold on, I'm coming.
No, because you're
it doesn't
saying
talk about prima facie. I agree with you.
Okay.
I agree with you that the six doesn't talk about prima facie. That is why I spoke to you about the modern purposive approach of our interpretation. And also what GSC also recommends that or admonishes that when you're interpreting the Constitution, you look not only the letter, but also the spirit of the Constitution. Yes. What reflects the intention of the speaker of the framers of the Constitution. So my point to you is that even though the 1466 does not talk about prima facie, but it clearly in 146 because when you read the case of Agyekum versus Akoti and Attorney General, the court said that so as not to unnecessarily bother the Council of State with frivolous or unnecessary petitions for the Council of State and the President to form committees on every petition that comes. There should be a way to be able to see, or if you like, some unnecessary petitions. So it is the President who has to establish the prima facie before 1466 in itself will be triggered. What is 1466 in itself? By going to the Council of State for the Council of State to assist in the formation of the committee. And you see, my point I want you to understand is that prima facie is a decision on its own, because when the prima facie is established, it will affect the rights of the person that the prima facie has been established against. Why am I saying so? Because if you go to Article 146(11), it will suggest to you that as soon as the process starts, the President, when the President forms the committee, can now suspend the Chief Justice. How do you suspend someone without giving the person a hearing? What's that?
Yeah, but if you say that in law, you also hold on. In law, you also consider the letter and the spirit. In the spirit, How do you take a case that affects the Chief Justice to the Chief Justice to determine the prima facie of the case?
Absolutely. So that is why the Chief Justice cannot do so.
Exactly.
So if the Chief Justice cannot do so, who is the next superior in terms of the chronology of governance? The one that the petition has been given to, and that is the President of the Republic of Ghana. So, per a true and proper interpretation, the President of the Republic of Ghana should establish the prima facie against the Chief Justice.
So at what point does the Council of State come in?
The Council of State comes in right after the prima facie evidence has been established or case has been established against the Chief Justice, so that you consult for the committee to be formed.
Yes, but even though you're looking at a combined effect, it's saying that where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall appoint chairman of the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. That's for 6. So the President can do that in consultation with the Council of State to determine the prima facie, no?
Council of establishing prima facie. If that happens, it will go against what Agyekum versus Akote and AG wanted to, as it were, avoid. The Agyekum versus Akote and AG wanted to avoid the Council of State unnecessarily, as it were, coming before it, petitions that do not hold any water, frivolous and vexatious kind of petitions. So that's what I'm saying, that a prima facie was given to one person. As far as the justices of the Supreme Court was concerned, the President will have to form that, what do you call it, prima facie. So that's why we are going to the Supreme Court. The Supreme Court should give a true and proper interpretation to it. Well, you may hold your views, I hold my views, but as far as the interpretation of the Constitution is concerned, let's see what the Supreme Court will say.
Kindly hold on a bit. I have a lawyer, Dela Alifo, with me. I will ask you about those you have copied before I let you off. But lawyer, let me, have you come in at this level.
Yes, you see, unfortunately, what the Honorable is talking about is his mind. It's not the law. I don't know where he's picking those things from. And
he picked from the Constitution.
No, it's not in the Constitution. There's nowhere in the Constitution that the President must determine prima facie.
Okay, for that one.
Yes.
Okay.
So I don't, and you see, so he's guessing all of this, and so I think that it should be this. I think that because
yes, but he says that he's looking at a combined effect.
No, why combined effect when the 2 provisions have mentioned separate officials or
clearly
officers? Yes, because Article 1463 says that in the case of removal of justices other than the Chief Justice, then it prescribes how it should go. Then when it comes to 1466, it says that if it is about the Chief Justice, this is what must happen. You see, so, but I don't even want to argue the issue about the requirement of prima facie, because I think that it shouldn't have been the case at all. In the Agyekum case, I wrote something and I said that the court wanted to achieve a particular result. That is why, because if the text is very clear, simple, clear, anybody can pick it, read it, and understand. You don't need to be on any expeditious trip saying that purposive approach and all of that. It is clear. What the framers want is that in the case of a Chief Justice, there shouldn't be anything like a prima facie. Straight away, when the petition comes to the President, he, in consultation with the Council of State, sets up a committee. That is what is there. But again, I'm saying that I don't want to litigate that now. I don't want to argue, because there was a case law that says that once there was a requirement for prima facie case for justices other than the Chief Justice, it should also be the case for the Chief Justice if the petition is in respect of the Chief Justice. But that case doesn't say who should make that determination of prima facie. It doesn't say so. And the Constitution doesn't say so. So if the Honorable is saying that, he thinks it should be the President after he determines that before he sends the petition to Council of State, and for the Council of State to now set up a committee, that is wrong. It's nowhere. It's not written anywhere. So this combined effect thing.
Can you simply say it is wrong?
It's wrong.
I mean,
I'm saying it's wrong.
I'm not a lawyer. You guys are lawyers,
no,
but can you just simply say it's wrong? Because I think every lawyer has the independence of mind to interpret how they see the law, and you can also try. It's fine. Yes, that's why I am reading.
Yes,
and maybe challenging him on some of the.
Yes. So this is I'm saying that it's a very simple English. When you read, you understand it. So you don't need any lawyer to even explain this to you. It says that in the case of a Chief Justice, this and this and this must be done. And then somebody is saying that you need to bring a combined effect, and the combined effect is taking a provision that was in respect of other justices and saying that you have to read that on as well because the person wants to achieve a particular purpose. So he's injecting that into it. So, but in any case, you see, the determination of the prima facie itself is a whole matter. The fact that the prima facie, we are not even saying that because I said that I don't even want to litigate that anymore. We agree now that prima facie has to be determined. But as to whether the accused person or the one who is accused has to provide his or her response before the prima facie is even determined, it's another thing that we have to come to. That is not the case. That is not the case when you go to court and he's a lawyer. If he's going to court, you would see that all plaintiffs, even if in the case of criminal trials, the prosecution, they will present all of their cases, all of their evidence, call all their witnesses. And when they present everything, the defendant may decide that I will not speak yet. And then they will ask the judge that evaluate the evidence this side has provided and then determine if they have made any case against me. If they have not made any case against the defendant, the defendant will not be called upon to open a defense. So that evaluation of the evidence of one side is what is called the prima facie. Because you see, when the petition comes to the president, whether it is the president alone that has to determine the prima facie or has to do it in consultation with the Council of State, what it means is that they have to look at the petition and see if it makes sense at all. If it doesn't make sense, we are not going to worry the Chief Justice to respond. You understand? So that process of trying to make sense of it is the determination of the prima facie. So he's doing that with the Council of State, and then they will look at it and say, yeah, this, when you read it, you will see that, yeah, there's something in this for the Chief Justice to respond to. And now then they call upon her. Calling upon her is when they set up the committee, then she will go there and present her case. So this whole issue that they have to hear the person before the prima facie is determined, it is not, look, that is not the law. That is not what prima facie is about, and all of us know that.
But you saw what the Chief Justice also wrote, that she should be given a chance to go through the petition, and then after 7 days...
She's wrong.
What I'm not sure about, if she was quoting from the Constitution, after 7 days she will bring her response.
No, you would notice that she said that she had dealt with similar matters, and that's what she did.
Yes, involving
she didn't quote any law. Yes, she didn't quote any law and say this was so. She's only saying that when I was handling it, this is the way I handled it.
Yes,
and
but
so
it's not the same.
No, so it should be handled the same way. In my case, it's different from saying that this particular law says that before you make a determination of prima facie case, you must give me the opportunity to. You see, as soon as they give the Chief Justice the opportunity to present her case, it means that they have dealt with the case. The conclusion that will come from there will be a decision, will be sent.
Because my logic, and I'm not using law, my logic is a case has been made against me.
Yes.
A prima facie has to be established
yes.
to determine whether or not this must be made null and void, foolish case, or whatever it is.
Yes.
And you say I should be the one, the same person,
yes.
to determine the prima facie of the case. Is that what they're saying?
That is not even what they are saying. They are not saying so.
They want to see.
No.
She wants to see the case and present her response.
Her response, so that the response will be factored into.
Or the prima facie establishment.
Of establishing. That's what it's saying. It's not saying that she wanted to.
Okay.
But what I'm saying is that is not the law. And they know, all the judges know. And my friend, the honorable member, also knows that, look, one side presents evidence, and when you read whether it's a suit or whatever, this one is slightly different from a suit. When you read allegation, you must make sense out of it first, because the president and the Council of State can look at this and read it and say, this is foolish case. We won't even worry the Chief Justice at all to even say anything about it. That means that they have looked at it and they determined that there was no prima facie case against her, and so she will not speak at all. But when they look at it and they say, yeah, we've seen something in this, and she has to respond, it means that they have established prima facie. Okay. So at the time they are going through that initial process, they don't need to listen to it, because what they need. Look, when they listen to her and she presents all her response, all her defense, what is she going to do again if they set up a committee? He's coming to repeat the same defense.
Oh.
Yes. So at the time they are determining
whether there's a prima facie case. It is only the one side. You see, it's like the ex parte applications.
Yeah.
Ex parte applications that go to the court, one-sided application, the other side is not consulted, they look at it, and then they say that, oh yeah, there's some merit in this, so we shall grant it, and we'll give you 10 days, come back, and all of that. So it's the same thing, they look at it, the president has to look at it, and now the president doesn't want to do this alone, because the Constitution Article 1466 talks about consultation with the Council of State. Even that consultation is not for the purpose of determining prima facie, but because that Agyekum case injected this prima facie case into the Constitution, which I am even against, because if the text is very clear, the framers of the Constitution, they left it like that on purpose. They may know the reason why they wanted the prima facie case for other justice other than the Chief Justice. In the case of the Chief Justice, they straight away set up a committee.
Yes, because so the Agyekum and the Akwete case actually falls under, other justices.
No,
not necessarily.
No, that one is for the Chief Justice.
It's for the Chief Justice.
And their reasoning is that, and I am saying that, you see, the difficulty I have with the Supreme Court is that if it is one of their own, like the Chief Justice from the Supreme Court, you see, the court, let's not think that the judges are saints. They always look at ways to make sure that they make things a little better for you. Understand? So the point is that when they read the text is very, very clear, because it couldn't have been a mistake. You see, if they can argue that the Article 146, maybe it escaped the framers, that's why they didn't put the prima facie in there, then they can now inject it in there, so purposely produce. But just before that, in Article 146, 345, they mentioned prima facie. How could they forget in repeating the same in 146? So it means that it is on purpose. They don't want it there. They didn't want it there. And that is why they left it out. So it's on purpose. So why would you now, Supreme Court now will say that, no, for us, we don't care what the framers were thinking. We think that, once it was applied the same way to justice other than the Chief Justice, we will inject it also there. And until now that we are speaking, the Constitution has not been amended to give proper effect to that Agyekum decision. The Constitution in 1466 still remains like that. It doesn't mention prima facie. And so that case can be overturned easily, because there's nothing in 1466 that talks about prima facie case. The 1466 says if the president receives a petition, the president, in consultation with the Council of State, sets up a committee.
But that's the fear. But that's the fear Vincent is expressing.
Well, yeah, but that fear is unfounded.
If we get to a point where we have to overturn the Agyekum versus Akwete.
No, we should amend the Constitution. I'm saying that, look, if there was any ambiguity in that provision, that is when they would want to maybe inject something into it, because the court is supposed to interpret the Constitution. You see, and in fact, anytime we run to the court for the court to even interpret the Constitutions, we shouldn't even be doing that if the text is very clear. The letter is very clear. Everything is very clear. It says that if the petition is in respect of the Chief Justice, in consultation with Council of State, set up a committee, and then they prescribe the people who should be on that committee.
Yeah.
And then the Chief Justice goes there with all the defense that she has. Because natural justice also requires that she should be heard.
Yes.
So she will go there and present her case and everything. And then after that, whatever the committee comes with, then that will be the recommendation the president will have to act with. You see, so why would you say that, because they treated justices other than Chief Justice differently, and so they have to treat Chief Justice also the same way, when the Constitution says no. It is. You can't. Not, so they are rewriting the Constitution, and that is why.
I mean, there were a number of cases that have happened using the same Constitution, and yes,
yeah, that is why
I am didn't use the right law.
You see, that's why I'm begging the Supreme Court that they should not rewrite the Constitution a second time, because there's nothing in this Constitution anywhere that says that if a petition is in respect of Chief Justice, it must be given to the Chief Justice first. The Chief Justice's response must be factored or must be taken into account in determining prima facie case. If they agree to something like that, it means that they have added more words to the Constitution.
Yeah.
They have added more things to the Constitution. It is not in the Constitution.
Okay, but how about the 296? I'm going back to Vincent, but the 296 that he also makes reference to, he says that exercise of discretionary power, where in this Constitution or in any other law, discretionary power is vested in any person or authority.
Yes.
That discretionary power shall be deemed to imply a duty to be fair and candid, be a duty to exercise, the exercise of the discretionary power shall not be arbitrary, capricious. Okay, that is
I don't even see why this even comes in.
Okay, I get it.
I don't see that
It's actually just talking about the excesses.
They just want to confuse everybody, so they are dropping all
No,
of
they are
this.
not confusing everybody. Everybody has a right to it.
I don't see how it comes in, because there's a provision that prescribes exactly what the president must do.
No, but you see that.
Going back to this and say that if he acts according to...
but the case they want to establish using Article 146, 3 and 6, 296 is just backing up.
It's not
their
backing
case.
anything. It's not backing anything, because I am saying that, you see, if the president is acting strictly in accordance with Article 1466, then you cannot say that he's acting arbitrarily or capriciously.
Yes. Okay.
That is the point. So I don't see why they are dropping that in.
Okay. Let's go back to Vincent. Vincent, thank you for your time again. Is Vincent on, or he's gone? Okay. So okay, Vincent is back. Honorable, are you back? Can you hear me? Hello, Vincent. Okay, we're trying to engage the... Yeah. Okay, thank you. So this is the case made by Lawyer Alifo. But what I also want to, ask you is the about 12 copies that you've made to various, opinion leaders in this country. I would say His Excellency the Ambassador Delegation of the European Union to Ghana. We have His Excellency British High Commission. That is the British High Commissioner. We have the Royal Majesty King Taki Teiko True, the second government chair. We have the Ghana Bar Association, of course, and the Office of the National Chief Imam. We've copied them. We have the Christian Council. You've copied them as well. United States Embassy. You've copied them. Parliament House. You've copied them. I think you've copied Otum for Setutu as well. You've copied. What do you call it? You've copied the Ochihini. I'm waiting for a penny. I mean, it goes on and about 12 of them. Togbi Afedi as well. You've copied all of them. What's the reason behind all these copies?
But even before that, can I ask a question to my learned colleague who is in the studio? My question to him is that,
has he taken into consideration the fact that as soon as the process...
Can you on your video? Can you put on your video? Or you are at a place you can't video?
Because I'm very busy at the moment now, that's why.
Okay, so you want to pose a question that says...
My question is, has he taken into consideration the fact that as soon as the process starts with the president consulting with the Council of State, what happens is that the president can now suspend the Chief Justice, which is under Article 14611 of the 1992 Constitution.
You want him to answer, or is a...
Yes.
Okay, we talk. Okay, he said you should answer.
That is the position.
And second...
Yes, okay.
Absolutely. So my second question is, respectfully, do you also agree with the fact that the prima facie that will have to be made, or a prima facie in its sense, in its general terms, is a decision on its own? Do you agree with that fact?
Okay, if you can hold on for him to respond, lawyer.
No. Well, the first one, you see, whatever...
And for the records, Article 11 says that the president may, at any time, revoke a suspension under this article.
So that's why it's talking about that. If a prima facie is established, then that can be done. And he's thinking that may be unfair if they haven't listened to
the Chief Justice.
That is the position of the Constitution. And the framers knew why they left it so. And so the president, perhaps, that is where, perhaps, let me finish. Let me finish, perhaps. Let me answer.
Okay, Vincent, let him land. I will definitely...
Let me answer. I am saying that perhaps the action of the president under that particular provision is where maybe 296, maybe perhaps if you think that, well, maybe there was no prima facie or maybe the case is not strong and the president arbitrarily suspends the Chief Justice, then maybe that is where they may want to look at the 296 and say that, well, the president acted capriciously or whatever. Yes, but look, this is the position of the law. It is clear, it is plain. You see, plain, very plain terms. So that is it. Then let me answer
the second one.
Let me answer the second one before you move. You see the prima facie case. The prima facie case, though it is a legal term, legal principle, we all understand there's an everyday meaning to it.
It's a decision on it.
Yes, so you can also, when they bring you a case, you can, when somebody brings you, somebody comes to allege something about me to you, if it's not a court of law, you also can determine that what they have brought to you about me is useless, it's nonsense. It means that there's no prima facie. In your own terms, you have also determined your prima facie. That is it. So for this issue that if it is prima facie, look, the Chief Justice, you see, in the case of justices of other than the Chief Justice, where the Chief Justice alone is expected to determine whether there's prima facie, the Chief Justice is not a court. You see, it's not acting like a court. It's not acting. Yes, so you have to know that. So when it comes to the president, you see, you know, honorable, the one last thing before you come. You see, when you made your first submission, you said that in your mind,
you are being disingenuous to your viewers to the extent that the simplistic analysis that the Constitution is saying that words have already been given in the Constitution, and for that matter, it is that simple to interpret. Don't do that as a lawyer. You know very well that we have moved beyond that kind of interpretation. And today, the interpretation talks about the fact that when we are interpreting a constitution, you do so by way of a modern purposive approach. What is the modern purposive approach?
That is when the provision is ambiguous. Then you bring in all.
Hold on. Okay, Vincent. Hold on, Vincent. But by the point you're making, I'm sorry. By the point you're making, the constitution. Hold on. The constitution has been structured in such a way that even the modern purposive approach you're talking about is still allowed for even persons who are not lawyers to be able to understand anytime, anywhere when they read the Constitution.
So you make activist judges who change the law when they are coming out with all these principles.
Please, you as a lawyer, you know very well that when you check Chapter 7 of the Constitution, the removal of an electoral commission has not been clearly stated there. How do we now remove an electoral commissioner? It is because meanings are now intuited into what has not been written. For it to be in pari material with what the CJ removal is. Don't be disingenuous to your viewers. Make it look as if you are saying.
I don't really understand why you are saying I'm disingenuous. I'm rather sticking to the text.
Allow him.
The point I'm trying to make is that it is wrong ab initio to conclude that because something has been stated in the Constitution means that that is the right thing. No. Please, we have moved on from interpreting a document from the days of the Idris case, from the days of the success period case, where when a matter, or if like a constitution have to be interpreted, you have to go by way of just the literal meaning. At a point, we realize that when you are interpreting a constitution literally, it can give an absurdity. It can land you in absurdity. But the fact that it is literal doesn't mean that is what you are supposed to do. We have to even move on to where interpreters or judges have to even deal with the golden rule that was stated in the Green versus Pearson case. In that case, the judges made us know that there are terms that the law will clearly say A, B, and C, but the judges will twist it and give you a reason, it's like a meaning that is X, Y, Z. Does he know that or he doesn't know that? We move beyond all those places to now come to the modern purposive approach. So what is he talking about?
Well,
so
this modern purposive approach. This modern purposive approach, who discovered that?
Places where there seem to be it is in your interpretation act. Go and read it.
No, you see,
go and read it. It is in your interpretation act. It is in the interpretation. Go and read it.
To change the meaning, to change the simple meaning of the
an act of parliament.
No, that's not right.
Okay, Vincent, how does this? I'm sorry. The same constitution and articles we've relied on in the past to judge or give judgment on cases that we've been making references to. Does it change anything with this modern purposive approach you're talking about? Does it change with respect to all these cases? Does it change? Doesn't it stand the same?
I didn't get your question very well.
Can you hear me now?
Can you come again? I didn't get the question.
Yes, I'm asking that the modern purposive approach you are applying.
Yeah, I can hear you now.
Does it change the interpretation of the Constitution we've used in the past to, judge cases in any way?
See, even today, listen to me very well, Annie. Listen to me very well. And my brother and Lodele may have to also listen. Even if today the Supreme Court make a decision or interpret the Constitution, they will interpret it today for it to bring out a certain meaning. And that meaning, they will bring out a certain meaning. And that meaning will have to be one that is in consonance with the environment today. The same issue can come tomorrow. Okay?
Yeah.
The circumstances and the environment may not lend itself with the interpretation that was given yesterday. So the court, in looking at the mood of the community, can vary its own decision, and it's even the Constitution. The court sometimes is not even bound by its own decision, even at the Supreme Court.
Yes,
so my point I'm making is that
that's why they have to overturn this Agyekum matter. It doesn't make sense to me at all.
I'm listening.
The point I'm making is that, respectfully, in the circumstances that we find ourselves as a nation, considering the mood of the nation, it is proper for us to impute a meaning into Article 146 that allows for the Chief Justice to be heard for a prima facie, or if you like, for a committee to be formed against them. Even in the absence of the prima facie, as soon as the committee is formed, he can be suspended. When he's suspended, it is her right that has been affected. And you know that cardinal among some of these things is the fact that she needs to be listened to, or she needs to be heard. And that's what I'm saying, that you need to look at all these things in a holistic perspective. It is wrong to simplistically say that this is what the Constitution says, so be it. No, that is not good interpretation.
But I was asking where exactly the Constitution is stating that by all means she has to be heard now.
I have told you that it is not in Constitution.
But the letter and the spirit
is critical.
Okay.
It's not in the law.
But the letter is not enough.
Annie, I want him to also respond.
The letter is not enough.
Okay. Vincent, your learned colleague wants to pose a question.
You see, Vincent belongs to a party, a political party.
So do you?
Yes, I do. I am talking about a political party that championed a particular cause at some point.
Okay.
When it was in their favor, and one of their members had defected or had decided to go and contest as an independent candidate.
Yes.
They wrote a letter and said that by the Constitution, by this provision,
yes,
this person should vacate his seat. Then, years later, the same provision, when now it would affect them if the people vacate their seat, they ran to court.
Yes, but
with all this modern purposive approach and whatever that, now interpret that same provision which benefited us in the past, which we called for you to implement, for it to benefit us in Parliament.
Yes, but
now implement it the other way around for it to benefit us again.
Now,
it is the same thing they are doing.
Maybe that's why he's saying that the modern purposive approach can be used.
Well, that is why I have a problem, because every time we are just going to the judges.
Yes, and remember that with that particular case, most of their lawyers were on air. I can remember lawyer Ishak.
Yes.
on Good Morning Ghana saying consistently that the ruling of that particular case by the
was wrong.
Yes,
because that would serve their purpose.
Yes,
they
by
had to
the
push
Speaker
for that.
of Parliament was wrong.
Because they had to push for that. If it was going to favor them again, they would have said that first interpretation
no,
was
but
good.
that's for the reason you cannot really say.
So what I'm saying is that let's leave. The text is plain, it's clear. This text, you see, if they apply the text, the provision in this constitution to the letter, it wouldn't result in any absurdity.
Okay.
I don't see any absurdity.
Okay.
If they find prima facie case without listening to you and they said because of that you are suspended, you'll be suspended. When you are when they suspend you, after a committee hears the matter and they clear you, they will reinstate you.
Okay.
That is what the framers want.
Right.
So you cannot now be injecting other things into it and say, oh, it will not be affair if it happens like this and all of that. When the text is clear. If the text is not clear, yes, fine. We all can go on expedition trying to find ways to make it better. But it is very clear.
I pray that this modern purposive approach will be used, because then it means that it may even affect the Agyekum.
For people who think that they have leverage or they have support in the courts, we can always run and get this done our way.
Okay. Vincent, I was asking you the question about the officers that have been copied. What is the idea behind, the reasoning behind that? Okay, let's see if we can, raise Vincent Asifa back online. But so that's just examples we can put on the screen for you to see. These are
the letters.
Yes, the letters that have been copied. So if you read the one that's been copied to the office of FIDA, the president, FIDA, Ghana, Accra, blah, blah, blah. Dear Madam, urgent appeal to defend judicial independence. I write to you with great concern regarding the ongoing attempts by the President John Dramani Mahama to remove the Chief Justice in a matter that raises concerns about the political interference of the Ghana's judiciary. And take note that it's saying that the attempt by the President.
You see, Annie.
And that's what I wanted to ask Vincent about. I think he's gone off. Ask him when we get him back. The one that's been copied to the National Peace Council, it says that I write to express a concern about the ongoing attempt by the President again. So almost all the letters to the Peace Council, the captions are all different depending on where it's going.
And you don't even have to even worry about the
manipulation.
contents of this letter.
I need to, just for the purpose of the viewers to know what's going on. So to the office of the traditional head, that's Togbi Afede, the 16th, said that with deep reverence for your leadership and wisdom, I write to humbly seek your intervention in the growing concern over the President John Dramani Mahama's attempt to remove the Chief Justice under the circumstances that suggest political interference. Okay, so it numbers about 11. One is going to Amweti of Penny. With deep reverence for your leadership and wisdom, I write to humbly, seek your intervention in the growing concern over the President John Dramani Mahama's attempt to remove the Chief Justice under circumstances that suggest political interference. So all these persons are expected, to come on board and help fight to sustain or maintain and keep sanity the judicial service. Lawyer.
You know what? These letters is just an act of desperation. If they have confidence in the court, you have gone to court, you have filed 2 suits. If you have confidence in that, the Chief Justice has made a formal request to the President on the back of your 2 suits at the Supreme Court. If you have confidence in that, why are you asking all these people also to come in and come and force the President? Assuming they all go and talk to the President and the President drops the process, the petition, and then the court rules that, the President is right to go on, then what will be the effect?
But I mean, it's personal.
No, so this is interference with the judicial matter because you have gone to court, you have filed your suits. Let's wait for, in fact, some of us, we are even jittery because I'm saying that not necessarily because the court is biased. That is something we can discuss another day because the perception is out there. But I am saying that if the Chief Justice is one of them, in fact, she may even be the one that may even constitute the panel that's going to hear the case. I don't see how that should be the case. But even if she is not the one, it is her colleagues that are going to sit on the case anyway. You see, so some of us are jittery. But if you have confidence that the judicial process will work very well, why are you now writing to Chiefs Tumfo, Togbi Afede, feeder and all this, but to still put pressure on.
It's all part of the governance.
So that the president,
it's all part of the governance system.
Look, we heard that during Atamil's time, there was a petition against the Chief Justice. We heard that. We don't know if it is true. And he didn't forward that petition to the Council of State. He thought that, no, it was not necessary. Ghana is for all of us. You know, and some people believe that he breached the Constitution. Mm-hmm. Because, you see, some people describe the president in this particular matter as a conveyor belt. Mm-hmm. If the petition comes to you, the Constitution is very clear. Forward it to, not necessarily forward it. It says that in consultation with the Council of State, you must act in a particular way. And so the petitions have now come, and then you are writing to all these people to tell the president not to act. He should leave it. He should breach the Constitution. For you, the same people should turn tomorrow and say that this president doesn't obey the Constitution. It's violated the Constitution, and so he should be impeached. So I don't see. So look, I beg these people, if they are listening, they shouldn't even interfere. They should allow the president to do his work. He took an oath, and he should do his work. If the president is wrong, the courts are there. They take the president to the court. Because again, Ghanaians are worried.
Tadosori said,
yes,
Vincent should allow the law
to work. Yes.
Is that what you're alluding to?
Yes, that's what I'm saying. They should allow the law. In fact, that should even mean that they shouldn't even have gone to court at all because the president hasn't done anything wrong. But they've gone to court. That's fair enough. So, well, let's wait. We although I'm saying that some of us are jittery because the courts of late, you know, but still they've gone to court. They have every right to go to court.
You didn't complete the statement.
Well, yeah, I've said those things over and over before, so we don't need to be repeating them all the time.
The court of late has done what?
Well, what Ghanaians have been saying about the court, that's what I'm saying.
You're also saying that.
Yes, but I'm saying that, and this is a fair comment, that the justices that are sitting there, they are the colleagues of the chief justice. Mm-hmm. You see, she may even empanel them, or whether she even empanels them, you know, I don't know. But we are just hoping that the court will also look at the law. They shouldn't rewrite the Constitution again. They shouldn't put in the Constitution what is not there. You see, as far as the terms, the provisions are very clear, and everybody can read and understand them, they should interpret them the same way. They shouldn't say that, oh, we think that, no, it should have been like this. They should have added this one where they didn't add. If they didn't add it, they didn't intend to add it. That is the point. They didn't intend, but unless they can go to what we call the legislative history.
Yeah.
That is, if they can go to the notes of the framers of the Constitution, the notes that they made and what was in their mind at the time they were framing the Constitution and all of that. But it is very clear that, look, anybody who picks this Constitution and looks at Article 146, 3, 4, 5, and then looks at 6, nobody can say that the framers forgot to bring the prima facie requirement to Article 146. Yeah. They deliberately left it out. Perhaps, perhaps they are holding the Chief Justice in such position in a very high esteem, very high standard. So they think that once they can establish a prima facie case, straight away, you should face a committee. Maybe that's what they want.
Yeah.
That's what they want. You see, that's why they need.
You're saying maybe.
Yes, because everybody is saying maybe. The people who even brought the prima facie requirement is also maybe.
Yeah.
But because they are judges, they said that, well, we think that because that's what was applied to other justices, so it must be applied to. But the people left it out. And they didn't forget. I am saying that you have to follow the law, follow the Constitution. If you can tell clearly, and it's reasonable that, oh, they forgot something, they skipped something. But here, how can you make that argument?
It's interesting because a number of Ghanaians are calling for the amendments of the Constitution, but there are some critical people in this country. Gami, I was saying Gami is one of them, who thinks that this Constitution is one of the best constitutions in the world, and its provisions are not necessarily bad, except that those who have been put in office to, practicalize the Constitution are the ones who are making the Constitution appear.
Yeah, I agree to a very large extent. And you see, and that is why we have to fine-tune it. They have to put us in a straitjacket. Because you see, once they give us a little freedom, people abuse. For instance, once they have not capped the number of justices that has to be in the Supreme Court,
okay,
a particular president may come and appoint 20,
exactly.
25.
So the people just come and they decide to
Yes.
do what they want.
Yes, and so now that is creating a situation for, I believe that the reason why it was not capped, maybe there may be circumstances, a very, very serious situation, under which perhaps the president may have to increase the number, maybe wartime, and they need some decisions or whatever. It may be anything, you see. But once we may have presidents who would want to manipulate that to the advantage of their political family, now they are putting us in a situation where everybody says, cap it. Cap it, don't take out that privilege, that freedom, so that in case we need it, we do. You see, so that is what is happening. You see, so when we had a president who can appoint somebody like me, everybody knows that I am speaking for
a constituency.
Yes, I ran in parliamentary primary. I campaigned for NDC. I trained NDC polling agents. I communicate for NDC, and they go and make me the chairperson of the Electoral Commission. You see, and you think they will not speak, but they did. We had a president who did that. You see, and the people didn't speak. Oh, now wait, if your mama does it, you see how all of them will come out and say, oh yeah, when it was done in the past, it doesn't mean it was right. We spoke before you spoke. What did you do about it? So we should allow him also to act, as long as we are not in that straitjacket yet. And there's room for him to also act the same way as Nana Akufo-Addo. He will do far better than him anyway. So but he should also just take advantage of some of the things.
Okay, our time is almost up, but let me pick your mind on this before we wrap up. From the Office of the Attorney General, a lot has been happening. Firstly, it was the oral team that presented this information, and the Attorney General indicated that it was going to investigate. So they started doing their work, and then all of a sudden, boom, we had the Kwabena Edubuahin matter come up, which is now on the table. It seems it has a lot of angles that the AG must deal with, and that's what we're dealing with now. But the criticism has been that you seem to have such a good case to present to court. I mean, he's still gathering more information, though, according to the press conference he held. But he seemed to have a good case to go to court. Why the public? Why is he, trying to play populism?
It's not about populism. We want to know. The public wants to know. You see, if you were in the campaign trail, some of you were not in the campaign, you were doing your thing in your studio. Yeah. Those who went to the ground and we listened to Ghanaians, you see, this oral thing was a result of what President Mahama had on the ground when he taught the whole country. Ghanaians want to see prosecution of people who have wronged this country, people who have stolen from the country.
So
you understand?
And
so there's an extreme public interest in some of these matters.
Okay.
And for Attorney General, I have seen it before. If you and you've been watching foreign news and all of that. You see the Attorney General, district attorneys in the US, they always organize press conference. They always give some amount of information to the public about what they are doing, about the investigation, how it is going, about the people they have arrested. So it is good. Then we follow the process. Then we all know that, this is what is going on. It's better. Because, and again, the Attorney General was under intense pressure. We all know. People were saying this, or where has he gotten to?
I mean, he
Nothing
said
is
it.
happening.
The question was thrown to him. Is he under pressure? He said yes, not under pressure from the political quarters, but under pressure from the public.
Yes, so if there's nothing wrong with it, then whether somebody likes it or not, once there's nothing wrong with it, it doesn't violate any law. In fact, it doesn't violate the right of the accused person. People are saying that you have tried the person in public.
In public.
Yeah, there's nothing like try in public, because the point is that when the Attorney General speaks, the person can also speak. His lawyers can also speak to the public. Everybody can speak to the public. So there's the real fight before that person will be punished, it has to be in court. So they all go to court, present their evidence in court, and then they will battle over there.
I mean, today we're now battling with the fact that the wife of the first accused is now first accused. What am I speaking law?
The accused.
The first suspect.
Okay, yes.
Yes, the wife of the first suspect is now going to court over bail.
Yes. Yes, because, I think what happened is because the bill that was granted them by Yoko, I think the conditions were harsh. That's why they claim. And so they have to go to court, because it is only court that can vary. If Yoko is not prepared to do it, and they go to court, now they can make a case for the court to vary the bail conditions. And that's why I believe they went to court.
Who determines the bail conditions? Is it the authorities in charge that determines the heaviness of the case and use it to determine the bill
Yes, yes. In court, yes, the judge, they will look at the offense. They will look at the charge. They will look at the
seriousness of the matter.
The seriousness, because the seriousness would determine the kind of punishment the person may have.
Yes.
And then they will also look at the person if the person is a flight risk. Flight risk means whether this person can run away from the country.
Okay.
If it is likely that the person may escape, they may not even want to grant bail, or if they will grant bail, then the conditions will be really very harsh, severe, very harsh, because then they may ask for justification. If they say justification, it means that somebody or some people may have to come and deposit their property, the document of their property, so that if the person escapes, they will hold them responsible. They will take their properties and all that. So they determine the bail conditions based on the circumstances of the case. And then especially, in fact, the flight risk is the most important thing, because you see, the whole issue is that when they need you in court, they must get you.
Yeah.
So if your family come and say, no, release him to us, anytime you need him, he will come. And there were situations where they will release people and then they vamoose. So they will give you conditions so that you make sure that the person comes to court and face trial. So if they still doubt that the person may come for trial, may come to court whenever the person is needed, then that's when
Are you running away from your own fears? Because in the previous administration, we had the boss of those who give the money loan.
Is it Maslock?
Maslock.
Yes.
Yes.
I
mean, she's been tried in absentia.
Yeah.
But we still not found her.
Yeah.
Is it a case of running away from your own fears?
Well, it can happen if her
Is that what is
situation
happening?
If her situation was the same as that. Well, fine. I don't know the circumstances. Yes, but that is what we all know. That she was tried in
typical
absentia.
example.
Yeah. So it can happen again with anybody. So that's it. That's why they have to look at the circumstances carefully and then look at the amount of money involved. Then that's how they grant, they set the bail conditions. Yeah.
So you think that the public hearing, the public updates,
we need more of that.
Attorney General, you should continue.
Yeah, it's good. It's good. I don't know if the amount of information he gave was necessary, though. But I'll defer to his judgment. But yeah.
What do you? I mean, I know you're a member of the NDC, but in your fair consideration as a lawyer, what do you think? Is the amount of information not too much? Because I sitting here, I'm not a lawyer, but I look at the case it presents and I'm like, your case is good enough, go to court.
He's a very experienced lawyer. He's our boss, and so I defer to it. In fact, I can't challenge him because he would have gone through everything and he believed that what he's putting out is okay. That's why he did it. So
by providing the information of properties acquired by the suspect.
Yes, that
monies
one
transferred by the suspect.
That one is fine.
Amounts
I didn't hear anybody complain about the properties and the amount. I heard somebody complain about he mentioning the name of the Yoko official that was in charge and all of that. Yeah, but again, like I'm saying, he's more experienced than me and than most of us. If he thought it was appropriate to put it out, then he put it out. We are behind him. We are supporting him 100% to do his work. Yeah.
We'll leave it here. All right. So that's all we have for you. We were not able to raise Vincent back. As you know, earlier on he told us that we were quite, busy in the House, the August House, as they are also preparing to rise. Parliament will go on break pretty shortly. We'll bring you up the updates subsequently here on Metro TV. Metro News is there, and we'll be with the members of Parliament until they rise. And so that's it. So, Lawyer Vincent Assefa, we're grateful for joining us here on Good Afternoon Ghana. And Lawyer Erica Alifo, I haven't seen you in a long while. In fact, the whole of last year.
Yes, I think so. Last year
I didn't see you.
Really? Was I not here last year? No, I think the beginning part of the year, the first quarter, maybe I was here once.
The first quarter.
I was very busy.
Yes.
I was in the thick of affairs.
Oh, yes, I can understand.
Now you can see victory has come because of the hard work we did.
Congratulations.
Yeah,
Congratulations.
Thank you.
Anyway, Lawyer Alifo is also a member of the NDC. He actually contested.
President of Linsod.
Linsod, yes.
Lawyers in Search of Democracy.
Are you still searching?
Yes.
You're still searching?
Yes.
Okay.
Yes, and so far our president is doing a fantastic job, and we are behind him, and we shall support him, and that is what Linsod is all about. Once he's doing the right things.
You are.
Yeah.
So he actually contested for the whole West constituency. Are you going again?
They said the politicians, and they don't say never, so, but I don't know. I haven't tried 2 times.
So
at this point, I don't know. I can't say that.
Okay, it's become expensive. If you think it is, don't waste your money.
It entails a lot.
Anyway, I'm grateful for your time, and I wish you all the best. All right, and thank you, viewers, as well. Today is Friday, so we'll pull the brakes on Good Afternoon Ghana. We're back next week with the program. Thanks for watching. Join us at 7 p.m. with News Night.
Me didn't tum. Mr. Femi Kalika, just call me cockroach. Now, Mr. Femi once now.
Hey, that's you. Improve car. Yeah.
Captain was key to double the accent. Me did it, Sasso spray. Mr. Femi Sasso quell. Yeah, to my Sasso
Sasso, come and tum preko.
So what about what your papa Diana?
This is my secret. Give us pea capsules. Hema wa won din ko from now on to me to my din won pem. Give us pea capsules. Overdo as mama. Ono enemy lawyer.
And to lawyer no na show bottom. Are you bro? They na pon me sin ba chia mo a ese ni die.
Bosano.
No. You never work out. The friend give us cold capsules. Say yes, is yare na wo so. Ko di do ni pedem wani na wo posa amamman entimi ma wunja wo nan yi. Wonum give us cold capsules a. Obeye free.
Lawyer.
Give us cold capsules.
And give us pea capsules.
Hey, and give us free.
And men what if you do what you do cronkwan efa. Give us core capsules. A painful a batter one more menu for an inquada when if you do me nunca.
Attention all farmers. Are you ready to take your crops to the next level? Introducing 3 effective organic composts that will revolutionize your farming practices. ACAP, KCAP and Irrigation brings to you the ultimate solution for your fertilizer needs. Introducing the ACAP Grade A, KCAP Equiafwajinkwa, and the Irrigation with cocoa blends, palm blend and mulch. These are made from locally sourced municipal solid waste, and these are the perfect choice for sustainable farming. Join the organic revolution today. Boost your crop yield, improve soil health, and support sustainable farming practices. Choose ACAP, KCAP, and Irrigation organic compost for a greener and bountiful harvest. For your purchase and more information, call the numbers on your screen. Our products are endorsed by Cocoa Board, Planting for Food and Jobs, and the Ministry of Food and Agriculture.
Dasibre Kwaku Boateng III, Omahini of New Drabin Traditional Area, Nana Drabin Sewa II, New Drabin Hima, Nana Amwenima Okukudrufo, Sushen Hima, Nana Abena Enchiwa Nkabum Hima of New Drabin, Ebisi Penny Nana Kofi Chiame, Germany, Oba Penny Comfort Omane